What if, without knowing it, you signed away your right to sue your employer for legitimate claims of discrimination, including retaliation? This may sound far fetched, but it happens more often than you think. On today's video, we're talking about how to know if you've signed such an agreement and if you have, what you can do about it if you experience discrimination or retaliation at work. And stick around until the end because I'm going to share the top 5 ways to avoid getting caught up in the very pro employer agreement. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. On this channel, I talk about real legal cases that demonstrate how the law might apply to your circumstances. Today's case might surprise you because many employees don't realize just how easy they can unknowingly waive their right to sue for legitimate discrimination claims. Let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. And don't forget to like and subscribe. This case starts with an African American woman who worked at Dillard's for years as a high performing sales associate at its North Point store in Alpharetta, Georgia. Now, the details regarding the number of years she was with Dillard's have not been made public, likely to protect her privacy, but we do know that she was someone who met Dillard's performance standards for a number of years before she complained about discrimination. After working a number of years at Dillard's, she became pregnant, and due to the difficulties she had during her pregnancy, she requested an accommodation due to the issues that she was having, and her supervisor at the time granted the accommodations to help her manage her pregnancy related medical condition. So, what happened was in February 2020, she received a new supervisor and he began to schedule her and conduct her employment relationship as if she did not have an accommodation. So she notified him of this accommodation that she had with the prior supervisor. And as a result, the supervisor, her new supervisor, moved her to a new department. And in this new department, she had a very difficult time reaching her sales numbers, and it was difficult overall for her to make the kind of income that she was making prior to her move to this new department. So she went to human resources and she complained in February of 2020, stating that the existing accommodations, which were fully approved by Dillard's, had been revoked by the store, this new store manager that she had. And she said that even though she informed the manager about those accommodations and the reason that they were there for pregnancy related reasons, that he would not honor them. So human resources did take the complaint, but what happened later is that she, in addition to being transferred to another department, they actually began to cut her work hours. So they didn't just leave her in the department where she was having a difficult time meeting her metrics and making the income that she was making before. They also left her in that department and reduced her hours. So her income went even further. It dropped even further. And she was furloughed in April of 2020 because this was during the pandemic. And a lot of people were furloughed at that time, but she was not recalled when others were. So she eventually was terminated in August of 2020, and she was replaced, but it was with someone who was a lower performing employee. Retaliation occurs when an employer punishes an employee because the employee filed a complaint reporting discrimination or some other protected right that they have. And some of the more common types of retaliation include firing or demoting an employee, cutting their hours, changing their schedule so that it negatively affects them, or giving them a bad performance review without justification for doing so. And sometimes an employer will even create a hostile environment, an environment that is so bad that it forces the employee to quit. And that's also retaliation. These types of retaliation are not always as common to detect and to describe, but when you document them, it does become easier to show that things are progressing over time and that there is retaliation that's taking place. The bottom line is that Title VII of the Civil Rights Act of 1964 protects employees from retaliation. If you want to know more about covert signs of retaliation and how to spot it, watch my video, Covert Retaliation Explained. Okay, so back to our case regarding the African American woman who requested a pregnancy accommodation from Dillard's and was denied and penalized. What happens next in her case is a bit of a plot twist because the EEOC stepped in, the Equal Employment Opportunity Commission stepped in on her behalf and sued Dillard's. So you might be wondering, wait, what? Why did the EEOC get involved? Why did they step in on her behalf? Well, Dillard's requires employees to agree to arbitration agreements as a condition of employment. And these agreements mandate that disputes related to employment, including claims of discrimination or wrongful termination, must be resolved through an arbitrator rather than through the court system. Many employees who sign arbitration agreements don't even realize they've waived their right to sue in court until they actually need to pursue legal recourse because they have been discriminated against. Oftentimes, employees are checking a box when completing new hire paperwork or checking in for their schedule for that day, and they're not fully reading or understanding what they're agreeing to. And even if they do read it, most employees wouldn't grasp the full implications of what they're forfeiting. And who can blame them? They're focused on securing a job, supporting their families, taking care of themselves, not deciphering complex legal language. These agreements feel like a deliberate way to strip employees of their rights, preventing them from legal action when they experience discrimination. And I believe these agreements are very pro employer, and this has actually been proven over time. One of the biggest wins for the employer is that they prevent class action lawsuits. And the courts have generally enforced these agreements when they've been challenged. So in this case, the employee was bound by the agreement and couldn't take legal action on her own. So the employee could not take legal action on her own, but the EEOC could. They could because they have been given the authority to file lawsuits on behalf of employees to address violations of federal employment laws. This authority is independent of any arbitration agreement that exists between employers and employees. So even if an employee has signed an arbitration agreement, the EEOC can pursue legal action in court to enforce compliance with employment laws. Now, the EEOC has this authority because of its duty to protect public interest and enforce anti discrimination laws, regardless of private agreements between employees and their employer. And before you start calling out Dillard's, let's be clear, it's not just them. Many companies across many industries require employees to sign arbitration agreements as a condition of employment. These agreements all mandate that disputes be resolved through private arbitration rather than through the court system. Some of examples of additional companies other than Dillard's that use arbitration agreements include Twitter. They implemented forced arbitration clauses to resolve disputes, and they include them in their offer letters. Square, which is this financial services company, it uses arbitration agreements for its employees as well. StubHub, which is an online exchange, ticket exchange company, they include arbitrations in their employment contracts. And you also have Marshall and TJ Maxx on the list. They've adopted mandatory arbitration agreements. And this is just a few of the companies that are using arbitration agreements to resolve disputes between employees, employment disputes. The bottom line is the use of these arbitration agreements has increased significantly over the past few decades. Well over 50% of American workers are subjected to these types of mandatory arbitration clauses, and this is a substantial increase over what we've seen even 20, 30 years ago. For example, in 1992, only 2% of American workers were subjected to these types of agreements. So, what happened in this case was Dillard's moved very quickly to settle the claim for $70,000. And as a part of the settlement, they were required to implement anti retaliation training. And the EEOC now monitors retaliation complaints at Dillard's. Arbitration agreements tend to be lower than court awarded damages. So, if the employee could have sued Dillard's in court, she might have received a substantially higher damages because it would have included, for example, back pay, emotional distress, compensation, and punitive damages. But Dillard's quick settlement helped to avoid a deeper investigation as well. So Dillard's has been very successful in using this strategy to control and ultimately silence employee complaints. It's still important to remember that just because you sign an arbitration agreement, it doesn't mean that you are out of options. You can still file a complaint with the EEOC and they can take legal action even if you can't. In addition, some arbitration agreements, they can be challenged in court because they're not written well, they're not sound legally, and so this can get the arbitration agreement thrown out so that it can be pursued legally in a courtroom versus with an arbitrator. So consult with an employment attorney if you decide that this is something that is that you've agreed to and you've been discriminated against, because they can help you determine the best course of action. There are ways for employees to protect themselves and avoid being forced into these arbitration agreements from the very beginning of that employment relationship. And here are some of the best strategies that you can use if you're confronted with this issue. Many employees don't realize they're signing an arbitration agreement because it's buried in onboarding paperwork. So before you sign anything, look for phrases like mandatory arbitration, waiver of right to sue, binding dispute resolution. If you spot an arbitration clause, ask if it's negotiable before signing. Some companies will actually remove or modify arbitration agreements if you just ask, especially for higher level or in demand positions. So, one way you can bring it up very easily is say, I prefer to retain my right to take legal action if needed. Can we remove or modify this arbitration clause? And even if they won't remove it, you might be able to negotiate more favorable terms, such as the ability to opt out later, the right to choose the arbitrator instead of the company picking one. So you just want to look for ways that you can, uh, you know, take control of that arbitration, the outcome of arbitration, and maybe even include an option for court appeals if the outcome isn't something that you think is reasonable. If you can, always choose to opt out. Some arbitration agreements have an opt out clause, meaning you can decline arbitration within a certain time frame after being hired. So check your contract for opt out instructions and follow them exactly. A lot of times they're buried in there and you have to look for them to figure out how to do it. Some companies will even send you an opt out notice via certified mail within 30 days of your onboarding. So just look out for opt out options that may be available to you depending on the employer. Some states have enacted laws to limit arbitration agreements. They include California, New York, and Washington. They all have restrictions on mandatory arbitration agreements. And so it's really important to know what your state laws are, because if the agreement that you've signed in some way violates your state's laws, that may nullify the agreement and give you the ability to pursue it in a courtroom. And the other thing is anything all of us collectively can do to raise awareness about what arbitration agreements mean and how they silence employees who are subjected to harassment, sexual harassment, discrimination. These types of agreements are very pro employer, but a lot of people aren't aware of them. So, awareness is a big key to helping to avoid and get entangled in these types of agreements. So, if you know what to look for, you know how to negotiate, you can avoid giving up your right to sue. If you have been discriminated against, if your Title VII rights have been violated, you've been, as we saw in this case, retaliated against because you asked for an accommodation due to pregnancy, you should understand that arbitration agreements that are too one sided, meaning they favor the employer heavily, or they are poorly written, or they are ambiguous, if you are forced into arbitration and you have experienced some of these violations, understand if your agreement falls into one of these categories so that you can challenge the agreement in court if it is not reasonable. So, consulting with an employment attorney to see if the agreement can be challenged is the most important thing you can do if you are being discriminated against. Have you ever been forced to sign an arbitration agreement? Do you think it was fair? Let's talk about it in the comments. I know a lot of people don't know about these topics in great detail, so go ahead and subscribe so that you don't miss my next video on workplace retaliation and other employment law breakdowns. Thanks for watching. I'll see you in the next video.